Ma'am, I need to see identification right now.
I already told you I have a hearing in 20 minutes.
That's not what I asked. ID.
On
Now.
what legal basis are you detaining me?
I'm asking for identification.
Then you can speak to court security. I'm going to my chamber. Hey, stop right there.
Two IC agents believed they were carrying out a routine workplace enforcement action inside the federal courthouse in downtown Phoenix. Acting on an anonymous tip about an undocumented cleaning worker, they arrived with badges, authority, and the kind of confidence that comes from operating in federal buildings as if no one could question them. But when they kept demanding identification from Judge Dr. Imani Caldwell, despite her calm, repeated explanations that she was a United States District Court judge heading to chambers, and when Agent Marcus Duval raised his voice to block her from entering the elevator at 8:43 a.m. on a Wednesday, they set off a chain reaction that would end in firings, a $6.8 million settlement, and Arizona's first federal prosecution of IC agents for civil rights violations. Caldwell wasn't just someone in the building. She was appointed to the bench at 41, a former federal prosecutor with 87 trials and an 84% conviction rate, a Yale Law graduate, and the daughter of a Birmingham civil rights attorney who had marched with Dr. King and defended freedom riders in Alabama courtrooms. She had chambers on the 9th floor of the very courthouse where these agents were confronting her. "I already told you I'm Judge Caldwell," she said again. They demanded ID anyway. She asked the legal basis. They escalated, and the lobby security cameras captured every second. Within 90 minutes, the Chief Judge of the District of Arizona, the U.S. Marshals Service, the Department of Justice, and Homeland Security's Office of Inspector General all knew exactly what happened in that elevator lobby. The settlement would be unprecedented, but the real cost wasn't measured in dollars. It was measured in reputations wrecked, careers ended, and a hard lesson about jurisdiction learned the worst way. The Sandra Day O'Connor United States Courthouse stands in downtown Phoenix, like a monument to federal authority. 10 stories of granite and glass housing the entire federal judicial apparatus for Arizona. Security is tight. Federal Protective Service at every entrance, metal detectors, x-ray machines, and credentialed access only. Judge Imani Caldwell had worked in that building for 6 years, first as an assistant U.S. attorney on the 5th floor, and later as a district judge with chambers on the 9th. She knew the guards, the marshals, the clerks. She knew the building like a second home. That Wednesday morning at 8:43 a.m., she entered to the West employee entrance, badged and using judicial credentials, and the security scanner logged it. Judge I. Caldwell, Chambers 97, access granted. She wore her black judicial robe over a white blouse and gray slacks, carrying a leather briefcase with files for morning sentencing in a meth trafficking case. 15 years on the line. The ground floor elevator lobby was designed to project authority. Marble floors, high ceilings, the seal of the United States District Court mounted on the wall. And it was there, as Caldwell approached the judicial elevator, restricted access for judges, marshals, and authorized personnel, that two men stepped into her path. ICE insignia on tactical vests, credentials on lanyards. They had been waiting, watching employees enter, looking for someone. Caldwell explained who she was and where she worked, but they didn't accept it. When she pressed the call button, Agent Marcus Duval positioned himself between her and the elevator while his partner, Benjamin Reeves, shifted to block the exit. "Ma'am, I need to see identification right now." Caldwell's response was measured and direct. She had a hearing in 20 minutes. She was Judge Caldwell, and she was going to chambers. Duval didn't care. "ID now." Caldwell's legal mind immediately recognized what was happening. ICE agents inside a federal courthouse refusing to accept her identity and insisting on detaining someone in judicial robes who had already cleared courthouse security. She asked a question that forces accountability. "On what legal basis are you detaining me?" Duval kept repeating the demand for ID. Caldwell told him to speak to court security if he had questions. She was going to chambers. That's when Duval snapped. "Hey, stop right there." The words echoed in the marble lobby while the cameras recorded the moment the situation crossed from improper to dangerous. Caldwell turned slowly, recognizing what she'd seen for years. Bias pretending to be procedure, assumption replacing evidence. She identified herself again, pointed out her security badge entry, her robes, her route to chambers, and told him to contact the Marshal Service. Duval claimed they were conducting immigration enforcement and needed to verify everyone in the building. Caldwell looked at him and understood the real meaning. Not everyone, her. The elevator arrived and the doors opened. Caldwell stepped forward, and Duval moved to block her. "You're not getting on that elevator until we verify your status." Caldwell answered sharply. Her status as a federal judge had already been verified. The security system had logged her entry minutes ago. Duval responded with the line that sealed their fate. "Anyone can put on a robe." In that instant, the confrontation stopped being a misunderstanding and became a documented display of racial profiling. Anyone can put on a robe, but not everyone can badge through federal security. Not everyone has a photograph in the courthouse directory, and not everyone has a chamber door with their name upstairs. Caldwell told them to verify properly. Call courthouse security, call the Marshals, call the chief judge's office. But you don't detain a federal judge because you can't imagine a black woman being one. Reeves hesitated, shifting uncomfortably, but Duval doubled down. "Turn around, hands behind your back." Caldwell didn't move. She stood in the lobby of her own courthouse and warned them plainly. They were attempting to detain a federal judge without probable cause or jurisdiction while security cameras recorded everything. Duval reached for zip ties as the elevator doors began to close. Caldwell didn't flee, didn't panic. She stood her ground and let the record build itself. Then her voice carried across the lobby. "Marshal." A deputy U.S. Marshal emerged from the security office. Taryn Bowl, a 12-year veteran who recognized Caldwell instantly and read the situation even faster. Caldwell told him the agents were attempting to detain her, claiming she matched the description of an undocumented worker. Bowles' posture changed, hand to radio, presence unmistakable. "Gentlemen, that's Judge Amani Caldwell, United States District Court. You're in her courthouse. Step back." Duval tried to hide behind the badge. "We have authority." Bowles shut it down. "Not here. In a federal courthouse. The U.S. Marshal Service holds exclusive law enforcement jurisdiction, and IC cannot conduct operations there without authorization from the chief judge." Duval certainly flickered, but he still didn't have an answer. Bowles demanded specifics. What exactly made Duval think a federal judge in robes with authorized access was a target? Duval's explanations collapsed into nothing. She was near the elevators. "We're checking everyone." Then Bowles radioed for a supervisor, reporting an incident involving IC agents and Judge Caldwell. As clerks and attorneys streamed into the lobby, the building itself became a witness. Another district judge, Adrian Lawson, arrived and immediately erupted. Caldwell had been on the bench for 6 years. They were in the same confirmation hearing. Lawson called it for what it was, not a description, but racial profiling. Security leadership arrived. Vincent DeMarco, a former Secret Service agent, now Chief Security Officer for Courthouse. He checked on Caldwell first, then demanded names and badge numbers. Duval pushed back. "We're federal agents." And DeMarco made the rules clear. Inside this courthouse, they answer to courthouse security and the U.S. Marshals. Duval and Reeves complied under the weight of witnesses and cameras. DeMarco pressed a key question. Where was their authorization to be there? Did they have a warrant? Duval tried to claim they didn't need one, and DeMarco corrected him. In a federal courthouse, you do. ICE cannot operate there without coordination and explicit permission. Duval had none. DeMarco spelled it out point by point. They entered without authorization, and when they saw a black woman in judicial robes with obvious authorized access, they chose to detain her because she matched female and black. DeMarco called it what it was. Civil rights violation, racial profiling, done to a federal judge on camera. DeMarco secured their credentials as evidence, giving them a choice: surrender voluntarily or be detained while marshals collected them as part of an investigation. Reeves complied immediately. Duval resisted for 10 seconds, then handed them over. They were ordered to remain in the security office under marshal supervision, not contact supervisors, and not delete communications. Marshals escorted them away while the lobby watched two agents get treated like suspects in the building they thought gave them unchecked power. Caldwell called the elevator again, rode to the 9th floor, and proceeded with her 9 a.m. sentencing as scheduled. She delivered a 12-year sentence. 3 years on the guidelines, based on cooperation and circumstances, and never mentioned the lobby incident in court. When she returned to chambers, the chief judge wanted to see her immediately. Chief Judge Sylvia Hartman was already on the phone with the IC field director for Arizona and didn't hide her contempt. The courthouse was not a shopping mall, and tips didn't override jurisdiction. The agents remained detained under supervision while Hartman demanded their communications, tip documentation, and operational authorization. They produced none, only an anonymous phone call. Caldwell admitted what Hartman already understood. She was angry, insulted, and not surprised. She'd been mistaken for court staff, interpreters, even defendants before. Hartman asked what she wanted, and Caldwell answered like a prosecutor. Full investigation, DOJ Civil Rights Division, Inspector General, a pattern review, and a clear message that IC has no courthouse jurisdiction without explicit authorization. Hartman issued a standing order. No IC enforcement in the courthouse without written permission and marshal coordination. The investigation confirmed the worst. Duvall and Reeves had been partners for 3 years, conducting 127 workplace operations, many triggered by vague tips describing people as African American or appearing from Africa or the Caribbean. Most resulted in 0 arrests, 0 findings, wasted resources, and fear in workplaces. Their arrest history was reviewed, defense attorneys filed motions, and the anonymous courthouse tip collapsed under scrutiny. An undocumented cleaner named Tanisha, with no last name, no specifics, only black female cleaning worker. There were 9 women named Tanisha working in the building, all black, all documented U.S. citizens. The tip justified nothing. Their text messages revealed intent, references to diversity hire, plans to check the elevators, and a belief that a federal building meant federal access. They were wrong. Federal buildings operate under specific jurisdictions, and courthouses answer to the judiciary. ICE required authorization and coordination. Written in policy, they ignored. Their supervisor, Gregory Stokes, approved the operation by text. Do it. These judges need to learn. We're not asking permission. And he was suspended within 48 hours. A federal grand jury convened 8 weeks later. Duvall was indicted on deprivation of rights under color of law, exceeding authorized jurisdiction and conspiracy to violate civil rights. Reeves received lesser charges in exchange for cooperation. Stokes faced charges for authorizing operations he knew violated policy. Caldwell testified without notes, stating the core truth. Duvall saw a black woman in judicial robes with courthouse credentials and decided she must be an undocumented cleaning worker. The grand jury returned indictments on all counts. The Phoenix trial drew national attention, and the security footage dominated the news cycle. Duvall's defense pleaded mistake and misunderstanding. The prosecution showed pattern and intent. The jury deliberated 6 hours. Guilty on all counts for Duvall. Guilty on reduced charges for Reeves. Guilty for Stokes. Duvall received 4 years in federal prison, enhanced for abuse of authority and a pattern of conduct. Reeves received 14 months. Stokes received 30 months. All were led away in handcuffs. Careers finished, reputations destroyed, and pensions forfeited. The civil settlement followed within 4 months. ICE agreed to pay $6.8 million, the largest federal courthouse settlement in Arizona history, rather than endure a public trial exposing systemic failures across state operations. Caldwell directed the funds. $2 million to immigrant rights organizations, $1 million to legal aid for immigration cases, $1 million to judicial diversity programs, and a remainder to establish the Augustus Caldwell Jr. Civil Rights Legal Defense Fund, named for her father. ICE entered a consent decree requiring written authorization for courthouse operations, mandatory marshal coordination, specific probable cause documentation, and civilian oversight. Policies that had existed before, now federally mandated because someone ignored them on camera. Caldwell returned to work the next day and never stopped. She kept the same routine, the same docket, the same standards. But she did change one thing. Every new lawyer who entered her courtroom got the same introduction. Professional, precise, and quietly personal. She reminded them she was Judge Caldwell, a former federal prosecutor, and the daughter and granddaughter of civil rights attorneys. She told them constitutional rights have to be defended constantly in every courtroom, and she expected the law, not assumptions about who belongs in the building. To be honored. Some understood immediately. Others learned as they watched the rule. Fair, exacting, and uncompromising on constitutional limits. The lobby where it happened still looks the same. Marble floors, high ceilings, the seal on the wall. Nothing marks a confrontation, but the cameras still record and the protocols still govern. In DOJ databases, the case remains active as a training reference. Unlawful detention of federal judicial officer. Location, outcome, conviction, settlement, reform. And the lesson remains simple, brutal, and permanent. Some judges you don't detain in their own courthouse. Caldwell proved it by standing still in an elevator lobby while 2 agents proved that badges don't excuse bias. And jurisdiction doesn't bend ego.